Last but not least, Clause 61, Payment Nominated Subcontractor and or Nominated Supplier. In PAM 2018, I found Clause 27.5, Payment by Contractor to Nominated Subcontractor, while in CIDB 2000, I found Clauses C3, Payment Nominated Subcontractor and or Nominated Supplier. For comparison, PAM 2018 and CIDB 2000 provide flexibility in payment structure, with CIDB 2000 integrating supplier into the process, while PWD203A enforce strict government regulation for financial control. PAM 2018 relies on architect certification. CIDB 2000 ensures structure, schedule, and PWD203A mandates government oversight for compliance. We can relate this to a Malaysian case, which is Gamuda Berhad versus PPK Construction Sdn Berhad. In this case, the dispute revolved around the issue of payment to nominated subcontractor under a construction contract. The contractor Gamuda Berhad had entered into an agreement with PPK Construction Sdn Berhad, where PPK was the main contractor. The project involved several nominated subcontractors for specific work, including electrical and mechanical installation. The main issue in this case was whether the main contractor was able to pay the nominated subcontractors on time and whether the nominated subcontractors could claim directly from employer Gamuda Berhad. If the contractor failed to make payment, Gamuda argued that the payment should only be made after certification by the architect that delays in the payment were due to dispute over the final valuation of work completed. However, the court held that under the standard terms of the contract, the contractor was required to pay the nominated subcontractor out of the sums paid by the employer. If the contractor failed to make such payment within the stipulated time, the employer was allowed to pay the nominated subcontractor directly and recover those sums from the contractor in line with the provisions set out in the contract. The remaining clauses will be explained by Muhammad Farhan.
Assalamualaikum warahmatullahi wabarakatuh. My name is Muhammad Farhan and today I will be presenting clause 62 until 70 from PWD form 203A and comparing it with PAM contract and also CIDB. The first clause 62. Clause 62, no liability of government to nominated and or subcontractor or supplier. In PAM, this is the closest clause is clause 7, nominated subcontractors, while in CIDB it is the clause 49, governing law. While comparing the three, only PWD 203A explicitly includes a clause 62 excluding the government from any liability to nominated or subcontractors and suppliers. The related case in this clause is Bauer Malaysia Sdn Berhad versus 100 Vision Construction Sdn Berhad and Anna. For clause 63, it is the responsibilities of contractor to nominated and or subcontractor or suppliers. In PAM contract 2008, the closest clause is clause 27, falls under nominated subcontractors, and while CIDB is clause 7, general obligations of the contractor. While comparing the three, instead any such liabilities fall upon the main contractor, even if the employer nominated or suggested the subcontractor. The case related to this is SPM membrane versus SPM membrane switch Sdn Berhad versus Kerajaan Negeri Selangor. Next is clause 64, intellectual property rights. In PAM, the closest clause is clause 7, royalties and intellectual property rights, while in CIDB is clause 35, indemnity provisions. While comparing the three, PWD 203A strictly vests all intellectual property rights in the government and places full liability on the contractor for any infringement, including indemnification. The cases related to this is Hexagon Tower, Sdn Bhd versus Polydynamic Holdings, Sdn Bhd. The next clause that I'll be talking about is clause 65, antiquities. In both conditions of contract, they also have this clause. For PAM, it is clause 33, while CIDB is clause 39. While comparing the three, all three conditions of contracts recognize antiquities discovered on site as the property of the employer or government and require the contractor to cease work, protract the object, and notify the appropriate authority. The cases related to this is the case of Ketua Pengarah Jabatan Warisan Negara versus PKNS. Next is clause 66, is the clause arbitration. In PAM contract, the closest is mediation, while CIDB clause 34, mediation, while CIDB is clause 47, settlement of disputes. While comparing the three, it outlines structured processes for dispute resolution. Initially, disputes are addressed by designated officers or superintendents, with binding decisions unless contested. The related case is Mega Juta Construction Sdn Bhd versus SPNB Aspirasi Sdn Bhd. Next is clause 67. While all three conditions of contract have the same clause, for PAM it falls under clause 38, or for CDB it falls under clause 8. While comparing the three, all three clauses emphasize the importance of written communication and timely delivery of notices, with specific methods for serving them. The case related to this is Jabatan Kerja Raya Malaysia and ANO versus Sunisa Sdn Bhd. Next is clause 68. Safety at the site. For PAM, the closest is clause 1, contractor's obligation, while for CIDB is clause 14, safety at the site. While comparing the three, the PWD203A, PAM 2008 and CIDB 2000 contracts all place primary responsibility for site safety on the contractor, regardless of approvals from the superintending officer. The case that is related to these three clauses is CIDB versus Tuxin Engineering and Construction Sdn Bhd. Next is clause 69, advance payment. For PAM, the closest is clause 30, certificates and payment, while CIDB falls under clause 42, payment. Comparing the three, PWD203A is the only one with a clear standardized provision for advance payment, including mechanisms for security, conditions of entitlement, and structured recovery in contrast. The cases that are related is Siti Indah Construction Sdn Bhd versus BHL Gemilang Sdn Bhd. Last but not least is clause 7, amendment. The closest in PAM contract is clause 1, contractor's obligations, while for CIDB is clause 51, miscellaneous provisions. While comparing the three, PWD203A provides the clearest and most direct procedure for formal contract amendments, requiring mutual written consent via supplementary agreements. The cases related are Port Klang Authority versus Kuala Dimensi Sdn Bhd.
That concludes our breakdown of PWD203A, PAM 2018 and CIDB 2000. Understanding this contract is essential for effective project management. Thank you for watching.